Questions and answers on alternative dispute resolutions. Question: what are the alternative modes of dispute resolution available in the Philippines beside CAM and JDR? Answer: besides CAM or Court Annexed Mediation and JDR, Judicial Dispute Resolution, the alternative modes of dispute resolution in the Philippines include arbitration, mediation, early neutral evaluation, mini-trial, and mediation arbitration, or any combination thereof. Question: what is arbitration? Answer: arbitration is a process where one or more arbitrators appointed according to the parties' agreement or rules under the ADR Act of 2004 resolve a dispute by issuing an award. Question: what is mediation? Answer: mediation is a process facilitated by a mediator chosen by the disputing parties. The mediator helps facilitate communication and negotiation, assisting the parties in reaching a voluntary agreement. Question: what is early neutral evaluation? Answer: early neutral evaluation involves bringing parties and their lawyers together early in the pre-trial phase. They present summaries of their cases and receive a non-binding assessment from an experienced person to aid in negotiating an amicable settlement. Question: what is a mini-trial? Answer: mini-trial is a structured method where the merits of the case are argued before a panel of senior decision makers. Following this, the parties attempt to negotiate a settlement based on the panel's feedback. Question: what is mediation arbitration? Answer: mediation arbitration is a two-step dispute resolution process combining both mediation and arbitration. Question: what is the primary law governing alternative modes of dispute resolution in the Philippines? Answer: the primary law governing alternative modes of dispute resolution in the Philippines is the ADR law, or Alternative Dispute Resolution Act of 2004. Question: how is international commercial arbitration regulated under the ADR law? Answer: international commercial arbitration under the ADR law is primarily governed by the UNCITRAL, or United Nations Commission on International Trade Law, which is the Model Law 1985. Question: what law governs domestic arbitration in the Philippines? Answer: domestic arbitration in the Philippines is primarily governed by Republic Act No. 876, also known as the Arbitration Law. Question: are there special laws governing arbitration in specific industries in the Philippines? Answer: yes. There are special laws governing arbitration in specific industries in the Philippines. For example, Executive Order Number 1008 provides for the construction industry arbitration law. Question: has the Philippine Supreme Court issued specific rules for alternative dispute resolution? Answer: yes. The Philippine Supreme Court has issued Administrative Order Number 07-1108 SC, also known as the Special Rules of Court for Alternative Dispute Resolution, to regulate alternative dispute resolution procedures. Question: what types of cases are exempted from the Alternative Dispute Resolution, or ADR law, in the Philippines? Answer: the ADR law does not apply to cases involving labor disputes, civil status of persons, validity of marriage, any ground for legal separation of spouses, jurisdiction of courts, future legitim of heirs, criminal liability, and those which, according to substantive law, cannot be compromised. Question: under what circumstances can court proceedings be stayed in favor of arbitration, and what interim measures can be sought from the court during arbitral proceedings? Answer: court proceedings may be stayed if a party files a motion to refer the case to arbitration based on a valid arbitration agreement. Additionally, if the plaintiff fails to honor an agreement to arbitrate before filing a lawsuit, the court may suspend proceedings during the period before the arbitral tribunal is formed, or if the tribunal is unable to act. Parties may request interim measures from the court. These measures can include preliminary injunctions, appointment of receivers, and other necessary relief to preserve rights pending arbitration. Question: what is the legal effect of agreements reached through mediation in Philippine law? Answer: agreements reached through mediation carry the force and effect of res judicata, akin to a judgment on the merits. Therefore, no appeal may be taken from such agreements. Once a settlement agreement is reached, the parties may file it with the regional trial court. If enforcement of the settlement agreement is necessary, any party may petition the RTC accordingly. Question: how are arbitral awards treated under Philippine law? Answer: arbitral awards, except those under the construction industry arbitration law, generally cannot be reviewed on errors of fact or law when seeking court confirmation. Courts may only modify an award based on evident miscalculation or mistakes in descriptions of persons or property referenced in the award. Awards may be vacated for specific grounds outlined in Philippine law, such as corruption, fraud, evident partiality of arbitrators, or if arbitrators exceeded their powers as defined in the ADR law, the Uncitral Model Law, and Republic Act number 876. Question: what are some arbitral institutions in the Philippines for resolving disputes? Answer: in the Philippines, several arbitral institutions handle different types of disputes. We have the Philippine Dispute Resolution Center that has been overseeing alternative dispute resolution proceedings primarily for commercial disputes since 1996. We also have the Integrated Bar of the Philippines, which operates the Philippine International Center for Conflict Resolution for Arbitration. We also have the Philippine Mediation Center, which manages mediation through court proceedings, while the Construction Industry Arbitration Commission resolves disputes in the construction sector. Additionally, disputes involving electric power trading are arbitrated at the Philippine Wholesale Electricity Spot Market, and the intellectual property disputes are handled by the Intellectual Property Office of the Philippines. Question: which are some preferred arbitral institutions outside the Philippines? Answer: outside the Philippines, preferred arbitral institutions often chosen include the Singapore International Arbitration Center, the Hong Kong International Arbitration Center, and the International Chamber of Commerce International Court of Arbitration. These institutions are renowned for their expertise and neutrality in resolving international disputes. All right, if you find this video useful, please don't forget to like, share, and subscribe. Thank you.